rate of 15% on the sum of 13,230 naira 94 kobo from October 2018 to the final liquidation of the judgment sum. And 9, an order directing the defendant to pay to the claimant the sum of 960,000 naira only, being the unpaid hotel/temporary accommodation for repatriated staff in line with section 9.3.1 of the expatriate policy mentioned in the secondment letter of the claimant dated 10th of October 2008, and the sum of 50 million naira as general damages for the unlawful and unfair treatment of the claimant by the defendant. Summary of the facts. The claimant, Mr. Rotimi Magnus Adeoye, commenced his employment with the defunct Standard Trust Bank, which later merged with the defendant, United Bank for Africa PLC, on May the 4th, 2000, as evidenced by Exhibit 1. The claimant's employment was formally confirmed by the defendant on February 20th, 2001, marking the beginning of a long-term professional relationship that spanned over 18 years. Between March 2010 and April 2017, the claimant was redeployed to serve as an expatriate in Congo Brazzaville to advance the defendant's corporate interests, a fact admitted by both parties. Claimant asserts the contractual relationship between the parties was governed by his letter of employment, the staff handbook Exhibit C4, circulars and memorandum issued by the defendant, and following his secondment in 2008, the expatriate policy Exhibit C7. While on expatriation in Congo Brazzaville, the claimant alleges that he was exposed to a significantly higher cost of living and severe territorial hardship as he got approvals in Congo Brazzaville to augment his finances. In 2013, he suffered a serious illness that resulted in permanent spinal injury. He contends that under the expatriate policy, he was entitled to cost of living adjustment, in bracket COLA, territorial premium, and responsibility allowance, but that COLA and territorial premium were never paid. The claimant was abruptly recalled from his expatriate posting back to Nigeria on April the 13th, 2017, allegedly in breach of Section 9 of the expatriate policy, which requires advance notice, consultation, and structured repatriation. He, however, continued his service until his termination. On November the 5th, 2018, the defendant terminated the claimant's employment and issued a terminal exit pay letter indicating a payment of 962,462 naira 52 kobo. In lieu of notice, the defendant effected specific deductions from the claimant's terminal benefit amounting to 648,116,097 kobo for unearned salary and 92,392.99 for unearned leave allowance. The claimant alleges that he is entitled to responsibility allowance, in bracket cost of living adjustment, equivalent to 70% of his net salary for the duration of his expatriation in Congo, totaling 67.030.778.57 CFA or $134,061.57. He alleges underpayment of gratuity from both STB and UBL and shortfall in hotel accommodation upon repatriation, having been paid for only 22 days, contrary to the provisions of the expatriate policy. The claimant's father said that he sustained health challenges during his service, leading to the purchase of a wheelchair and claimed medical entitlement under the defendant's policy. While the defendant admits the employment history and the expatriation, he denied the specific financial calculations of the claimant, asserting that all lawful entitlements were paid as evidenced in Exhibit D1 and D2, and that the deductions were justified as unearned benefits. Trial in this matter commenced on the 11th day of November 2025. The claimant, being the sole witness, testified as CW1 and tendered the following documents admitted and marked as Exhibit C1 to Exhibit C23. The defendant also called one witness who testified as DW1 and tendered the following documents. They were admitted and marked as Exhibit D1 to Exhibit D3. In the body of the judgment, I have the defendant's final written address and also the claimant's final written address. I'll go straight to the decision of the court. First things first, one vexed issue both counsel raised and strongly debated on in their final written addresses was whether the defendant's staff handbook and expatriate policy constitute binding contractual obligations between the claimant and the defendant. In Nigeria, the contractual force of conditions of service and staff handbook varies significantly across the various categories of employment. The public service rules are a prime example of such conditions of service with statutory flavor governing public sector employment. In such instances, the conditions of service are not mere guidelines, but legally binding terms. It is true that not every statement or policy in a staff handbook or internal document automatically creates contractual obligation. Some provisions may be purely aspirational, procedural, or informational, intended to guide employees or management rather than to create legally enforceable rights or duties. For a provision to be contractually binding, it must be clear, unambiguous, and intended by both parties to form part of the agreement. If a policy is vaguely worded, subject to unilateral change by the employer without notice, or explicitly states that it does not create contractual rights, a court may be less inclined to treat it as a binding term. However, the burden will be on the employer to demonstrate that such a document or provision was not intended to be contractual. It is a law that in the absence of statutory flavor, conditions of service and staff handbook can become contractually binding if they are expressly or implicitly incorporated into the employee's contract of employment. This typically occurs when the employment letter or agreement explicitly states the employment is subject to the terms and conditions specified contained in a specific handbook or conditions of service document. In the instant case, the defunct UBA has the defendant UBA has vehemently argued that Exhibit C1, Standard Trust Bank offer of employment letter, is the only document binding on the claimant. The court took a look at Exhibit C1 and found it is an offer letter to the claimant with effect from May the 8th, 2000. It contains the breakdown of his remuneration, note on productivity bonus / profit sharing, request for medical certificate of fitness, notice on expected period before confirmation, 2 weeks notice for termination, and request for acceptance of offer within 7 days. The claimant in addition tendered Exhibit C3, an offer letter from UBA after the merger, where the defendant stated his employment is subject to internal regulations set out in the staff handbook, circulars, and memoranda. This Exhibit C3 reads, and I quote, "We are therefore pleased to offer you appointment with our new institution, United Bank for Africa, as follows. Employment history with the predecessor bank shall remain continuous and cumulative into the new UBA and shall be subject to the internal regulations of the bank as set out in the staff handbook, circulars, and memoranda issued by the new bank from time to time. These terms and conditions supersede any prior ones between you and the predecessor bank." End of quotation. This court notes that in Exhibit C3, UBA expressly referred to the staff handbook tendered as Exhibit C4. Meanwhile, in the handbook on page 8, it states thus, and I quote, "The purpose of the handbook is to set out some of the terms and conditions of employment. It is not a contract of employment, nor is it intended to create contractual obligation for UBA of any kind." End of quotation. In employment law, the position of the law is that where a letter of employment refers to a staff handbook or corporate policy, those documents become part of the res gestae of the contract. The principle of pacta sunt servanda, it dictates that parties must be bound by the terms they have voluntarily entered into. In Oforishe versus Nigerian Gas Company Limited, citation provided, the Supreme Court held that documents incorporated by reference into an employment contract are binding. The Court of Appeal in Adekunle versus UBA PLC citation also provided underscored the importance of conditions of service in the contract of employment, implying their contractual significance. When a contract of employment refers to a staff handbook or condition of service, those documents are deemed to be incorporated into the contract and their provisions become binding terms between the employer and employee. Therefore, any breach of these incorporated terms can give rise to a claim for breach of contract. Again, Schwaible and NBC PLC Coca-Cola, citation provided, is particularly instructive. This case dealt with the status of contracts governed by an employee handbook. The Court of Appeal emphasized that the character of an appointment and the status of an employee are determined by the terms and conditions of the contract of employment. If an employee handbook is expressly or implicitly made part of the contract, its provisions become binding. This case supports the view that employee handbooks sorry, there was a break. Again, in Schwaible and others versus NBC PLC, again, Schwaible and NBC PLC is particularly instructive. This case deals with the status of contracts governed by an employee handbook. The Court of Appeal emphasized that the character of an appointment and the status of an employee are determined by the terms and conditions of the contract of employment. If an employee handbook is expressly or implicitly made part of the contract, its provisions become binding. This case supports the view that employee handbooks, when properly incorporated, do create contractual obligation. Mustafa and NTIDA citation provided further clarifies what determines the nature of a contract of employment, reinforcing the principle that the terms and conditions, whether in the primary contract or incorporated documents, define the relationship. There is no doubt that some policies might be purely regulatory. However, conditions of service and staff handbook in Nigeria frequently create contractual obligations as shown in the cases cited above. A party cannot abandon the contractual term without proper notice or agreement. This is the bedrock of contractual stability as affirmed in Main Street Bank Registrars Limited versus Ukandu. Unreported suit number NICN LA/335/2013, judgment delivered on May the 27th, 2015, where the court emphasized that in determining entitlement, particularly in labor disputes, the court must consider the entire contract, which includes staff manuals, letters, and other relevant documents. Therefore, any blanket statement that they merely regulate performance and do not create contractual obligations is largely incorrect in the context of Nigerian employment law. After evaluating C1 and C4, this court further finds that by Exhibit C6, which is the letter of secondment, he provides for terms and conditions for his secondment outside the primary country of employment. There is no doubt in the mind of this court that the above mentioned exhibits C1, C4, C6 are all pointers to the fact that the claimant's employment was regulated not only by the offer letter Exhibit C1, but the staff handbook, letter of secondment, expatriate policy, having been drafted and issued by the defendant, he cannot now disclaim them. Accordingly, the parties are bound by the contract of employment together with the incorporated handbook and policy documents I so hold. The claimant is seeking a declaration that the purported sum of 962,462.52 being payment in lieu of notice as stated in the defendant's letter of 9 November 2018 is a nullity as same contravene the terms contained in the letter of employment and the staff handbook of the defendant regulating the relationship between the claimant and the defendant. From the statement of fact, claimant pleaded that he was invited to the head office on Monday, October 15, 2018 and instructed to resign immediately. By Friday, October 19, at about 12 noon, his computer was disabled from the bank's network and a new officer was posted as a branch manager. He had to write his resignation letter on the 19th of October. On the 2nd of November 2018, his account was credited with a sum of 17,153,710.88. He received a letter dated 9 November with a breakdown and the calculation of the said sum. The court noted that the defendant issued two responses to the resignation letter Exhibit C14A and Exhibit C14B. Both reflected payment in lieu, that is 962,462 naira 52 kobo. By the letter of employment Exhibit C1, it provides thus, and I quote, termination of appointment by either party shall be by notice in writing of not less than 2 weeks, and for a default, 2 weeks basic salary in lieu of notice is required. While page 64/62/64 of the handbook Exhibit C4 provides for a 1 month duration or payment of 1 month salary, 1 month basic salary in lieu of notice. The crux of this matter is the claimant's challenge of the adequacy and legality of the payment made by the defendant to terminate the employment relationship without the required notice period. The claimant argues that the amount of 962,462.52 does not reflect the true value of the salary for the notice period required by his contract and to contravene the staff handbook and should be declared a nullity by this court. The defendant, on the other hand, argues that the payment in lieu was calculated based on the claimant's basic salary and applicable allowances as defined in the bank's exit policy. The defendant asserts that the claimant accepted the payment at the time of termination, which implies an agreement with the calculation. The validity of a payment in lieu of notice depends entirely on whether the sum matches the current salary or total emolument defined by the contract. If the contract specifies salary, it usually refers to the basic pay. However, if it specifies emolument, it must include allowances. Under Nigerian labor jurisprudence, where an employer opts to terminate with immediate effect, the payment in lieu must be made contemporaneously and must be the exact amount the employee would have earned during the notice period. Any shortfall renders the termination wrongful, though not necessarily void. In this case, notice was given on the 15th of October, and the claimant tendered his resignation later on the 19th. The defendant, in response, paid salary in lieu of notice in accordance with the Exhibit C1 and the Staff Handbook Exhibit C4. He exhibited as exhibited in Exhibit C14A and C14B. It is the finding of this court that the defendant therefore paid salary in lieu as reflected in Exhibit C14 and A and B in compliance with the terms of employment. This is the finding of the court. I so hold Relief 2 fails. Relief 3 is for a declaration that the deduction of 648.116.97 and 92,000 naira 92.392.99 described respectively as unearned salary and unearned leave allowance from the terminal entitlement of the claimant via the defendant's letter of 9 November 2018 is unlawful and a breach of excellent labor law and international best practices. While Exhibit 4 is for an order directing the defendant to pay forthwith a sum of 740.509.90 representing the unearned salary and unearned leave allowance that were unlawfully deducted from the terminal exit pay of the claimant by the defendant. In the instant case, the claimant pleaded in his additional witness statement of oath that the defendant paid additional sum of 5,519,013.70 kobo, representing the unpaid outstanding leave commuted to cash. In other words, the unearned leave allowance had been paid. Also, in Exhibit 16, claimant admitted that his leave arrears was paid. Therefore, Release 3 and 4 is taken care of and is accordingly dismissed. The fourth relief sought is for an order directing the defendant to pay the sum of equivalent to 70% of net salary responsibility allowance from March 2010 to April 2017, being the sum of CFA 67,030.778.57 or $134,061.56 as at 2017 as cost of living adjustment in line with Section 6.5 of the expatriate policy mentioned in the secondment letter of the claimant dated October the 10th, 2008 and redeployment letter of March 11, 2010. And interest at the rate of 10% per annum on the sum from April 2017 when the claimant was recalled back to Nigeria until the entire sum is liquidated. For this relief, the claimant in proof of this claim relies on Section 6.5 of the expatriate policy, which explicitly grants this allowance to all expatriates, and the secondment letter of 2008 and redeployment letter of 2010 for his entitlement to the 70% allowance as a mandatory entitlement rather than a discretionary one. The defendant, in discharging the burden of proving payment or showing a waiver by the claimant, argued that the responsibility allowance was either already paid, was already included in the claimant's monthly expatriate pay, or that the claimant did not meet the specific criteria for his adjustment during his tenure in Congo. Besides, he is of the opinion that the claimant's failure to raise this issue for 7 years while in Congo suggests the claim is an afterthought. In examining the specific wording of the redeployment letter Exhibit C8, there is no doubt that the claimant's employment metamorphosed into an expatriate status, which was regulated by the expatriate policy of Exhibit C7, incorporated by reference into the secondment agreement. On what COLA really means, the court found that Section 6.5 to 6.5.2 clearly defines COLA as a mechanism crucial for managing cost of living differentials between the employee's home and host countries to safeguard the employee's relative home purchasing power for essential goods and services exclusively within the host country, covering daily living expenses such as food, clothing, and local travel, in bracket fuel. The court noted that paragraph 3 of the secondment letter, Exhibit C6, unequivocally promises and I quote, annual hardship/dislocation allowance in line with the expatriate policy, end of quotation, for relocation outside the primary country of employment or to an offshore branch. The claimant, to further prove he is entitled to this relief and that the cost of living was higher in Congo, tendered the following exhibits. Exhibit C19, which was procurement of 3 inverters and batteries costing 23,905.650 locally, while importing them from Lagos, including taxes and logistics, brought the cost down to 11,107,931 naira, less than half. He also exhibited Exhibit 21, Exhibit C21, which is importation of other resources like note counting machines from Lagos, which saved the bank $3,264 compared to purchasing them locally in Congo Brazzaville. He tendered Exhibit C21, which was evidence of purchases of 3-volt doors from Nigeria, resulting in a significant saving of about $61,000 by avoiding a local supply in Congo Brazzaville. He also tendered Exhibit C23, which was an approval of feeding for 45 people, including during finacle training, which cost $10 or CFA 5,000 per person in Congo Brazzaville, a cost 3 times higher than the equivalent $3 or 500 naira CFA 1,500 in Nigeria. Now, on whether the claimant secured prior approval to entitle him to execute these purchases, the court noted that the approvals were got from the COOUBA Congo, COOUBA Congo, COOUBA Africa, and COOUBA Africa. So in other words, the purchases were valid and to the knowledge of the defendants. This court is convinced that from a community reading of the expatriate policy, the secondment letter, the redeployment letter, and the above exhibit standard, the claimant was qualified for COLA, and the cost of living was higher in Congo than in Nigeria. If the defendant could make such significant savings exhibited in the above exhibits C19, C21, C23 on hardware items purchased for bank use, then there is no doubt that prices of food, clothing, and fuel could not have been exempted. UBA, who drafted the policy and was saddled with the responsibility to review annually, see section 6.5.3 of the expatriate policy, but failed to do so, cannot use this as a ground to deny the claimant of this benefit. The law upholds a party from benefiting from his own default or negligence. Notably, the defendant stated in the statement of defense that COLA and the payment of territorial premium are not absolute entitlement, that the defendant had the absolute right to change its percentage approach because he earned the salary in Nigeria, and other payments and extra benefits such as the cost of basic school fees of his children and loans at special interest rates were all benefited by the claimant. This court notes that it is standard practice for employee on secondment to continue to earn their home salary. Neither are they deprived of home benefits and access to loans like any other staff if they so qualify. Besides, if UBA wanted the terms otherwise, it had an obligation to inform the claimant before he was seconded to Congo or during his work time in Congo, and not to rely on the argument that the group reserves the absolute right to change the percentage and approach at point of demand for entitlement. This would amount to changing the goalpost in the middle of the game. The exhibits were tendered without objection and remained unchallenged and unrebutted. The court also recalls that DW1's testimony did not controvert the fact that the claimant suffered inflationary pressures or hardship, but merely argued absence of a formal complaint. Secondly, she admitted that she had never visited Congo Brazzaville, rendering her unable to credibly dispute the claimant's detailed assertions regarding the cost of living. This court agrees that the contractual right does not evaporate simply because the claimant failed to demand payment while serving abroad. A right to entitlement is triggered by the existence of qualifying circumstances, not the claimant's willingness or failure to complain. In the circumstance, this court grants an order directing the defendant to pay the sum equivalent to 70% of net salary in bracket responsibility allowance from March 2010 to April 2017, being the sum of CFA 67.030.778.97 or $134.061.56 as at 2017 as cost of living adjustment, in line with section 6.5 of the expatriate policy mentioned in the secondment letter of the claimant dated 10th of August 2008 and redeployment letter of March 11, 2010. With regards to the interest at the rate of 10% per annum on the sum of this amount from April 2017, when the claimant was recalled back to Nigeria, until the entire sum is liquidated, this arm of the relief is put on hold until the end of this judgment. I so hold. The sixth relief is for an order to pay to the claimant the sum of 95 CFA 95.758.225.10 or $191.516.51, representing the sum due to the claimant as territorial premium for exposing the claimant to territorial hardship suffered by the claimant while in Congo Brazzaville from March 2010 to April 27. From March 2010 to April 2017 as an ex parte on secondment in line with the ex parte policy mentioned in the secondment letter of the claimant dated October the 10th, 2008, and interest at the rate of 10% per annum on the sum of that amount from April 2017 when the claimant was recalled back to Nigeria until the entire sum is liquidated. The expatriate policy in section 6.6 to 6.7 provides for territorial premium, which is expressed as a percentage of the gross basic salary, designed to provide compensation for the assessed level of difficulty an employee faces in adapting to a new country. The basis for this claim is as a result of the severe health challenges and permanent disability to his spine in the Congo as exhibited in the medical report from Congo Exhibit C10 and C11, a direct consequence of his assignment. That required him to be flown to Nigeria due to lack of quality medical facilities. The expatriate policy Exhibit C7 specifically provided for health-related matters and repatriation. Even though parties are in agreement that the claimant benefited from the insurance scheme and was flown to Nigeria for treatment, claimant maintains that the defendant's policy already made provisions to cater for such a situation, such as health challenge, through the payment of territorial premium. Now, back to the expatriate policy. Again, there is a clause for review of the territorial premium, see section 6.7.1, and also the amount is based on data provided to the group by an independent third party taking into account key aspects of lifestyle, see section 6.6. By section 6.7, there is provision for a percentage of gross basic salary and calculated based on each posting assessment. Since the defendant had no data provided by an independent third party and the defendant never averred that the policy was reviewed, this policy is also silent on percentage of gross basic salary. How the claimant arrived at 100% of the responsibility allowance amounting to CFA 83.567.15192 or $167.134.88 was never made known to the court, except that to the claimant it was a fair and reasonable sum to support his permanent disability. This court is therefore left to invoke the contra preferentiam rule, whereby the drafter of a document cannot benefit from its omission or its ambiguity. In claimant's pleading, even though he stated he had made repeated demands for payment of COLA and territorial premium, but HR refused to present the cost of living adjustment for approval, he also failed to tender evidence of such application to enable this court evaluate the percentage of gross basic salary he had applied for. Defendant was also silent on this fact. This court acknowledges that the failure of the defendant to determine the percentage an expatriate staff is entitled to cannot work against the employee. Parties are bound by the terms they agreed to, just as COLA was provided in the expatriate policy, and a percentage of gross basic salary allocated to territorial premium, on the other hand, is an agreed term, yes, but no percentage of gross basic salary was allocated to it. In the circumstance, this court cannot impose a percentage sumo motu. Relief 6 fails, not because the claimant is not entitled to it, but due to the fact that the policy is silent of the percentage of gross basic salary, and the court cannot draft a policy for the parties. I so hold. The relief 7 is for an order directing the defendant to pay 22,715.019.15 kobo naira, being the value of the total gratuity due to the claimant as at the time of his unlawful disengagement by the defendant, contrary to the sum of 3 million plus paid from September the 1st, 2005 to October 2018, and interest at the rate of 15% on the sum of 22,715.019.15 from October 2018 to the final liquidation of the judgment sum. Relief 8 is also for an order directing the defendant to pay forthwith to the claimant the sum of 13 million naira 213 naira 94 kobo, representing the entitled gratuity of the claimant in line with the defendant's handbook addendum of the defendant, and interest at the rate of 15% on the sum of the amount from October 2018 till the final liquidation of this judgment sum. The claimant disputes the defendant's calculation of his long service gratuity, claiming a significant shortfall. This claim for 22 million is based on his total years of service, that's 2005 to 2018, and the terms of the staff handbook. The defendant maintains that the sum of 3 million plus paid was the correct and final amount due under the bank's gratuity scheme as it existed at the time of his exit. Now, when Standard Trust Bank merged into UBA, the employees accrued 3.038.381.97 kobo gratuity became a transferred liability to UBA. Although gratuity is typically payable at retirement and therefore was not due in 2007, the legal question is whether paying the exact nominal amount 13 years later satisfies the obligation in substance. Under Nigerian employment law, gratuity is a vested benefit earned during service, and courts interpret such entitlements in line with fairness and the intention of the scheme. Given Nigeria's inflationary environment between 2007 and 2023, 3,038.381.97 million in 2007 does not carry the same economic value in 2023. Paying the unchanged principal risk defeats the purpose of gratuity, which is to provide meaningful pre-retirement security. Nigerian courts have in appropriate cases awarded interest or other monetary adjustment to prevent injustice where long-term monetary obligations mature after substantial currency depreciation. Therefore, even if the bank complied with the timing of payment, this court is of the firm conviction that equity and commercial fairness requires value preservation, and that additional payment of 2 million naira 944.637.88 kobo as full and final payment for his gratuity still falls short of the real economic worth of 3 million naira accrued in 2007. This court hereby grants relief 7 for the payment of the sum of 22,715,019.15 kobo, being the interest on the total gratuity due to the claimant as at the time of the unlawful disengagement from the defendant. This arm of relief 7 succeeds. The second arm, which is the interest rate of 15% on the sum of that amount from October 2018 till the final liquidation of the judgment sum, shall be determined at the end of the judgment, I so hold. Now, for the eighth relief, this court again refers to the claimant's admission in his email of 17th February 2020, tendered and marked as SDBC 16, that his leave arrears and full gratuity was paid. In view of this, the order sought in relief 8 is dismissed since it has been satisfied. I so hold. Relief 9 is for an order for 960,000 naira, being the unpaid hotel/temporary accommodation for repatriated staff in line with section 9.3.1 of the expatriate quarter mentioned in the secondment letter of the claimant dated October the 10th, 2008, and also the sum of 50 million naira as general damages for the unlawful and unfair treatment of the claimant by the defendant. Firstly, the undisputed facts are that the claimant was communicated on the 13th of April that his recall was with effect from May the 1st, 2017. In other words, he had 17 days to travel back to Nigeria after 7 years in Congo as an expatriate staff. The expatriate policy, however, clearly provides in section 9 that repatriation will begin at least 3 months before the planned assignment end date. Furthermore, section 9.3.1 provides for temporary housing for up to 2 months in the home country. The question then is whether claimant's recall to Nigeria was consistent with the established procedure outlined in the defendant's expatriate policy. The recall letter, Exhibit C13, clearly made no reference to section 9, section 9.1, or to section 9.2. The drafters of this policy, in a bid to cushion the relocation process, recognize that, and I quote, an employee may also encounter difficulties readjusting to life in the home country. This is often referred to as reversed culture shock. For example, life, family, and friends would have moved on during the assignment cycle, and readjustment will need to be made to different working practices. It continues. It is important to highlight that reintegration into the home country may not be as smooth as originally anticipated. Of the specific protections and procedural steps guaranteed to guaranteed to expatriate staff. Faced with the above scenario, can this court be convinced that UBA complied with its own expatriate policy, or was there an amendment to the policy? This court does not think so. Defendant did not rebut any of this. From his pleading, he was recalled back to Nigeria to report within 2 weeks, which was the end of the month of April 2017. Upon arrival in Nigeria on May 2017, he was promptly transferred to Ekiti State as a branch manager within 2 weeks of repatriation from Congo. UBA has no proof it provided for temporary housing for up to 2 months on his return to Nigeria. Claimant averred he spent 22 days in Lagos and 28 days in Ado Ekiti, but the defendant only paid for 28 days for his hotel accommodation upon repatriation to Nigeria out of the total number of 60 days spent, and refused to pay for the remaining 22 days contrary to the provisions of the expatriate policy. UBA's argument is that on arrival, the expatriate policy ceased to regulate the claimant. UBA's argument that on arrival, the expatriate policy ceased to regulate the claimant is obnoxious. Exhibit C7 speaks loud and clear, and this court is positive that the provisions of the handbook had not kicked in within the transition period of 2 months, that is 60 days, to regulate the claimant with regard to hotel and temporary accommodation. Since the expatriate policy governs repatriation and was incorporated into the contract, the claimant is entitled to accommodation support for the stipulated period. This court hereby grants an order for 960,000 naira to be paid by the defendant, being the unpaid hotel/temporary accommodation for repatriated staff as provided for in Exhibit C7, the expatriate policy, I so hold. The claimant is also seeking the sum of 50 million as general damages for the unlawful and unfair treatment of the claimant by the defendant. It is right that general damages are awardable per se upon breach and is compensatory in nature in monetary form, as assessed by the court in exercise of its equitable jurisdiction to compensate the injured party by the act of the breach of contract or injury inflicted. In NSCB versus Achagua, citation provided, the court clarified how general damages are determined thus, and I quote, "One of the characteristics of general damages is that it is fixed by the opinion of the court, so that
I'll call you back.
To be the direct, natural, or probable consequence of the act complained of." End of quotation. See also Odumosu and ACB Limited, Samoris and Maja, Union Bank of Nigeria versus Ajabule, citations all provided. In Shuka versus Abubakar, citation provided too, the court stated, and I quote, "The basic object of award of damages is to compensate the plaintiff for the damage or injury or loss he had suffered as a result of the action of the defendant, premised on the guiding principle of restitution interregum, that is, putting the plaintiff in a position in which he would have been if he had not suffered the wrong for which he is being compensated." End of quotation. Accordingly, this relief succeeds to the extent that the sum of 10 million naira is hereby awarded against the defendant in favor of the claimant as general damages for acts depriving the claimant of his entitlement and failure to respect the recall procedure of an employee who has spent 7 years outside his home country as provided in the agreed terms and conditions that bound the parties. This procedural inconsistency contributed to the overall betrayal of the employment agreement, which brings the court to relief one sought. The claimant argued that the defendant's refusal to pay full entitlement is a direct violation of the terms set out in the letter of employment, the staff handbook, and the expatriate policy, and such failure aligns with unfair labor practice as recognized under international best practices and Nigerian labor law. The defendant contends that all entitlements were duly paid at the time of his exit from the bank. Besides, the claimant failed to provide sufficient specific clauses that were breached to justify a declaration of unlawful practice. Having evaluated the facts and the evidence placed before this court today, and from the evidence taken earlier, decisions taken earlier in this judgment, this court hereby declares that the failure and refusal of the defendant to pay to the claimant all his entitlement arising from his contract of employment as stated in his letter of employment, staff handbook, and expatriate policy is unlawful, is wrongful, and constitute an unfair labor practice in line with the labor law and international best practices. Relief one succeeds, I so hold. All sums awarded shall be paid within 30 days from today by Order 47, Rule 1, Rule 7, failing which they shall attract simple interest at the rate of 10% per annum until final liquidation. Judgment is entered accordingly.
The court pleases.
We are more grateful to the judgment of the Honorable Court.
My Lord, we are very grateful for the well-considered judgment. We are appreciative of the time taken by your Lordship to dissect this case and then deliver judgment. We are grateful, my Lord.